Nana, for a person like me, Nana, there is a committee that the NDC, I think just a small historical perspective, the NDC sets up a committee to look at all these IPPs that have been signed and others. The NPP takes over. The NPP reconstitutes the committee. Okay. The committee presents a report. It recommends that, look, for those ones that have not come on stream yet, I mean, you could terminate some of them. And then they give you each one and what they believe you can do. In the case of this one, after analyzing everything, they recommend that, look, instead of the 24 million per year, on the basis of what has been done and what has not been done, you can negotiate with them, pay 18 million, and they give you the grounds for that. You can pay them $18 million and you end the story. What will make us, or what will make government decide that we won't go by that recommendation? We'll go ahead and even engage the company. And there's correspondence to the effect that they were engaged. That government created the impression that they were still in business with them. And then you then decide to unilaterally terminate the contract. They go to arbitration. You go there. You lose. They've attached 5 of our buildings there, including Chancery, High Commissioner's Residence, High Commission, and then Regina House. You lose the arbitration 134, and if you read the report, all what we said there, evidence, everything was there. And that's why I read the 490, which I thought that bit was a bit instructive. Then you go and pay 1.something million. 2021, you go and pay 1.something million. Then you leave the rest. Then they go to U.S. District Court under UN Convention because we are signatory. The court documents state that we were served through the foreign minister. We had over 1 month to make an appearance. We didn't do it. They also have given their judgment. And the thing about their judgment is that they have even given a post judgment interest compounded on a quarterly basis. Now we've been told that Regina House is gone. The other 4 is diplomatic cover, which is keeping them now. We don't know, with respect to the U.S. court ruling, what they will be going to look for in the U.S. Why? How did we get here? Why should we be here?
Yeah. Thank you, Randy. Before I get to your specific matter, let me also deal with the politics.
Okay.
Because I heard my brother Samuel Kujeto happily talking about recklessness and wickedness. And
depressingly, I'm very sad.
Cruelty and ineptitude, and that the government should be voted out and all of that. Well, I don't blame him for it's the political season, and I don't blame him. But let's look at the politics, the other side. I mean, this is not the first judgment debt that a country has incurred. And it cuts across regimes. I remember Bank Switch, where a contract was cancelled, 2009, 2010, and we had to go and pay. We lost the case. A judgment was delivered. We had to go and pay nearly $100 million. I remember ACES, where a contract that had been approved by Parliament was also cancelled in 2009, 2010. And we had to go and pay nearly $50 million. Of course, the most famous judgment debt is the Wayome judgment debt, where the court actually instructed what amounts should be paid. And yet, officials went beyond what even the courts had ordered. I remember the then Attorney General saying that even Samuel Kujeto got himself involved in that judgment debt.
Which one?
Sorry?
Which one, Woyome?
Was it Woyome that you mentioned?
No.
Which one?
I've never gotten myself involved in
But
any
you
judgment.
heard it. You heard it.
You are talking
He
about
stated
Yes.
for the record that I forwarded a petition which we received at the Ministry of Information. I was the then Deputy Minister for Information.
Over which judgment?
Over isophoton,
Isophoton.
which I forwarded to. That's and it's normal practice. You've been at the Information Ministry.
I'm not saying what you did it was wrong.
I've never been cited for any judgment there.
No. I'm not saying you have been involved in judgment debt. I'm saying that the Attorney General at the time even mentioned you as pushing for payment of judgment debts. So, judgment debts cut across. If you decide that it's due to recklessness and wickedness, you will say the same for the government that supervised the judgment debt that we had to pay over bank switch, ACAS, and the famous Woyome. So all the governments that we've had, NDC and NPP, we have been reckless. And we have been cruel. And we have shown ineptitude. Because at the time that we're paying for bank switch, at the time that we're paying all those millions to Woyome, there were women who had been detained at Kolebu because they couldn't pay their bills. There were ministers of state at that time who lost family members simply because their family members could not get beds at Kolebu. Those were the times that we were paying for bank switch. Nearly $100 million. We pay for ACAS, we pay for Woyome, and all of that. So that's the politics of it. If we want to go that way, I mean, we can always go that way and point fingers at each other. It becomes a NPP NDC thing.
Nana, before you go there, let me just provide some information, some further information.
No, it's okay.
It's okay. I have this from David, who says that I'm very disappointed in the High Commissioner of Ghana in London today. As Ghana's most senior diplomat in the United Kingdom, and in some ways the country's eyes and ears there, his advice to government about this Regina House matter is paramount. Yet, rather than let the whole country understand the gravity of the situation, he seems rather focused on helping the Attorney General spin the real facts on the ground. 1. Regina House was acquired by the Osagyefo from a City of London guild for Ghana Commercial Bank in 1961 to create a banking outpost for Ghana's international business in the UK. 2. The building itself was carved out of different addresses on the corner of Queen Street and the Plush, but ironically named Cheapside in 1939. It is close to iconic locations in the historic City of London, such as the Bank of England building. At one point, Barclays was the primary occupier. 3. It was mainly for the use of Ghana International Bank and other state affiliates until 2007, when the government started to lease portions out to Abe National, Ibasis, and Japanese bank Chiba. In 2015, Ghana successfully secured a deed of release from the City of London. In 2021, Government of Ghana lost an arbitration dispute with a Trafigura subsidiary that it should not have entered into in the first place. See below for detailed articles, so that's there. It then went to the High Court to set it aside, but despite an extension of time, it abandoned the case only to return later. The court dismissed the government's case and reaffirmed damages of nearly $140 million. 6. The government entered negotiations with Trafigura but failed to abide by its promises. Therefore, in March 2022, Trafigura went to a court in London to grant it a charging order against Ghana's properties in London. The judge issued interim charging orders. The government had more than a year to prepare before the orders were to be made final in May 2023. The government did not bother to show up and ask the judge to craft the orders in such a way to allow it to pay in installments or to delay payments or anything of that sort. It waited until it had been served before mounting another fruitless case, questioning why notices were not sent through diplomatic channels. The court dismissed this case too. Regina House was thus placed under receivership, meaning that someone else manages the property, collects the rent, and remits it to Trafigura. Nearly $2 million in rent has been paid out to Trafigura so far. I have checked the title register this evening and confirmed that contrary to the Attorney General's claims, The charging order is still active. It has not been vacated. The High Commissioner's posture suggests complacency and will be remiss if he fails to acknowledge that the charging order is a step on the ladder of money judgment enforcement. The judgment creditor, Trafigura in this case, has the option to proceed to a court and ask for order for sale. By making it look like there's no cause for alarm, he's endangering Ghana's assets. The Attorney General has refused to defend against other enforcement suits in Netherlands, the most recently the United States. Yet he gives the impression that all is under control. Meanwhile, the country has paid almost $90 million haphazardly outside an agreed installment plan and without negotiating for an interest freeze. Hence, the original debt amount, $138 million, has barely reduced, more than $112 million now. What game exactly is this? Ghana has various assets acquired over the years by state-owned enterprises like Cocobot, GCB, and Ghana Consolidated Diamonds in the UK and elsewhere that are vulnerable to seizure by Trafigura because they are designated for commercial rather than diplomatic activities. It is just a question of value and effort. Ghana also has bank accounts all over the world that could be said to be linked to commercial rather than sovereign activity and therefore could be subject to garnishee orders. By creating the impression that there is no risk, the government is playing chaskele with Ghana's assets. Please, this is not a time for spin and point scoring. Senior government officials need to be serious.
So but his main point is that the High Commissioner, is complicit?
No, he says that
the seriousness.
Yes, it's not that he doesn't think that is attaching the seriousness that he should to the case, and so he's giving us some details, especially on the Regina house.
Yeah,
that in fact there is there's been an order on it. We failed to go and challenge to set aside or vary the orders. We didn't do that. We had 1 whole year. We didn't do that.
And he believes that is the fault of the High Commissioner?
Yeah, he says that.
My own take on it.
He says rather than let the whole country understand the gravity of the situation, he seems rather focused on helping the Attorney General spin the real facts on the ground. That's his.
Why is he saying
that's
that?
His claim.
What is the basis?
So he goes on to give us what he believes are the facts of the matter.
Because the reason why I have a different opinion, before I come to
yes,
I mean the Attorney General has said that it's a straightforward loss in court, and so we have to find the money and pay. And so all of this attaching of the properties and so on are coming out because we haven't found the money. So I don't understand.
Does it suggest, Nana, that government prefers that rather because we entered into, according to the facts here, we entered into like a payment plan with Trafigura.
Yeah.
And we did not
We haven't
fulfill
been
it.
able to fulfill.
Yes.
Yeah.
Does it suggest that government will prefer that we lose this property and potential properties rather than look for the money to pay?
You can make that conjecture.
No, I'm asking.
No, but you can make that conjecture based on the situation, the facts of the situation. But I'm concerned about his charge that the High Commissioner, also Akomea, has to be blamed. That's where, because the government itself has accepted liability. So if you accepted liability, the only thing is to pay. Whether you have a payment plan, which you pay by installments or whatever, you've accepted liability, you have to pay. So this business about the High Commissioner not informing Ghanaians and all of that, the government is fully aware. The government has accepted liability. It's just that the payment has not been made.
Yes.
So why the payment has not been made, I mean, like you are saying that because of the consequent attachments and all of that, maybe if we paid, it would be better. Maybe government is trying to renegotiate or government hasn't got the money or whatever. But to say that the High Commissioner is hiding something, I don't get it from the statement that you read.